appeal in the matter of Ciftci and the Mayo and Burgesses of London Borough of Haringey.
May I please?
Yes, do everybody sit down.
I appear for the appellant.
Yes.
My little friend Mr. Evans, my little friend Mr. Mould appear for the
Yes.
local authority. And clearly this is our appeal in relation to the review decision of the 22nd of June 2020, and as a homelessness appeal, the focus is on the way in which that decision was made.
Indeed. I can tell you, Mr. Fitzpatrick, that we have read the review decision, the judge's judgment, and the skeleton arguments.
I'm very grateful. What I propose to do, perhaps slightly unusually, is just to go through very briefly the legislation and the authority insofar as we say are relevant to the issues. The issues are essentially, we say the reviewing officer applied an overly restrictive application of section 1912, and in relation to that an issue arises as to whether or not there's an onus on the applicant to put forward what relevant matters in support of their case. And essentially the respondents say it's not for them to delve into the prospects of employment in the UK. It's something that should be raised by the applicant. And that's a specific issue between the parties.
Yeah.
So
that goes to the scope of the inquiry.
Yes.
Which the housing authority is required to make.
Yes. And I think we say that that's addressed in the cases that we're going to turn to very briefly, in particular in O'Connor and F in Birmingham.
Yes. I mean, Alfonso El Trinidadi, if that's the right way to pronounce it, certainly suggests that the applicant must show that section 1912 applies.
Well, indeed. I'm going to come on to that.
Yeah.
I mean, yes. And there's also a reference in that to recklessness as opposed to the approach on good faith in the Ugabi case. I'll come on to it. The starting point is the legislation itself.
Yes.
And as I say, I'll go through very briefly what we say about the authorities. But we've got section 184 at tab 1, which sets out, there's no question here, reason to believe homeless threatened with homelessness. The authorities satisfy themselves eligible, and if so, what duty arises. So the duty of inquiry rests throughout with the local authority, and we say that includes at the review stage. Then we get section 191 at tab 2. And in relation to section 191, sets out subparagraph 1, becomes homeless intentionally if he deliberately does or fails to do anything, in consequence of which he ceases to occupy accommodation, which is available for his occupation and which it would be reasonable for him to continue to occupy. And in this case, there's no argument that the act or omission would have been leaving the accommodation in Switzerland in December or early January, December of 2018.
Yeah.
The protection, and we do refer to it as a protection under subsection 2, is to say that for the purpose of subsection 1, an act or omission in good faith on the part of a person who is unaware of any relevant fact shall not be treated as deliberate. It may be a deliberate act, but it won't be treated. And we say the statutory language is open. It refers to any unaware of any relevant fact. And in the early cases, and indeed in the leading case of Obeid, Lord Cornworth refers to the fact that there's no reasonableness requirement in there. So someone could be acting unreasonably in what they do, but still entitled to this statutory protection if they can establish that they were unaware of a relevant fact and they acted in good faith. And in relation to it, it's been pointed out again that we get the circumstance of honest blundering.
Yeah.
And it's better in a sense if you don't conduct a full plan or investigation, you may put yourself in a better position.
I'm sorry to interrupt you quite so early. First of all, is section 189A of any relevance here? That says if the local housing authority is satisfied that an applicant is A, homeless or threatened with homelessness, and B, eligible for assistance, the authority must make an assessment of the applicant's case. the subsection 2 says that assessment must include an assessment of the circumstances that caused the applicant to become homeless. That's part of the duty to inquire, isn't it?
Indeed, yes.
So it's not just section
Indeed, it's not. It was section 184, indeed. I mean, that's directed at priority need, isn't it? Section 189.
Well, that's one of the things,
yes.
Certainly. That goes to the personalised plan.
Ah, sorry, yes. This is under the homeless reduction provision.
Correct,
yes.
which applied, I think, at the time that your client made her application, didn't it?
I'd have to double check because it was in the application. It certainly, I think it applied, and I'll check the point. I think it applied in 2000 at the time of the review decision. 3rd
of April 2018, I think it came into force.
Well, her application was on the 7th of October 2019, and then it was. We get into 2020. I think I will check that.
Yeah, I thought the amendment that those amendments had come into force by then.
Yes, we will check that point, my lord. The other thing to observe as a preliminary point is the very fact that some of the cases we go to predate the introduction of Section 191. Previous incarnation was under Section 60 of the Housing Act 1985. So Section 191 came into force on the 20th of January 1997. And as I say, previously, there was discussions about whether a reasonableness clause should be imported.
Sorry, just date again, came in on what?
It's the 20th of January 1997.
Yeah.
So there was ample case law saying, even suggesting, that you might want to put in a reasonableness clause or adapt it. You could have removed any. But that wasn't done. The wording is exactly the same. And essentially we say that supports our case in terms of the approach to be taken.
Can I just ask you this? What is the relevant fact which you say your client was unaware of?
Well, in relation to the situation, there's two aspects. She had a job, employment that she was going to. Yeah. And essentially the difficulty we have is that the reviewing officer essentially doesn't grapple with it. She's got a job, and we know that it's working for this meat company, and she says it involves filing. It seems to be administrative. Now, the relevant fact is likely to be that she wasn't aware that there would be a lot. I'll come on to the facts, but it's been said on the one hand she wasn't up to the job, and it seems to be suggested there was quite a lot of standing around. She also refers herself to the fact we know she suffers from arthritis in her hands, and there was a problem with that. But essentially it's difficult because in all the cases...
So the relevant fact is what?
The relevant fact would be that she wasn't going to be able to sustain the job.
Right, and how is that related to the cause of her homelessness?
Well, because if you've got employment, if you've got earnings, you're in a much better position to find alternative accommodation if the accommodation you're in comes to an end.
But it's not what she's ever said, is it?
Well, yes, she's never said that, and I accept that. But we say, and it comes down to whether or not the local authority were required to delve into this aspect of the case. She's not said, I got on a plane and came to the UK and hoped to get a job and hoped to get a... She says, I had a job, and in fact, I'll come to it because there's an email from her that says exactly this. I didn't just come to the UK and apply as homeless. She came to the UK with a plan, may not have been a very good plan, but she had accommodation and she had a job. And we say that both aspects, and taken together, had to be looked into by the reviewing officer in assessing the protection under Section 1912. Because we know, my lord, that she's not someone who had no history of working. She'd worked for some 13 years as either a radio producer or coordinator, it's referred to. Presumably that's office type work. And she was coming to a job that on the face of it, she wasn't going to the meat company to work as a butcher. On the face of it, it was administrative tasks, and she said talking to customers.
So the relevant fact of which she was unaware was her inability to do the job.
Well, she would be unable to sustain working at the Rainbow Meat. I mean, that's a possible relevant fact, and also the reviewing officer doesn't really grapple with the issue of We know that she moved to temporary accommodation, and it looks pretty precarious on the face of the papers. But we don't know whether or not there was any assurance given in relation to that as to how long she might stay. We know that she did stay there for a number of months, and in the event she had to leave, and she refers to, in her answers to questions, she says that it was because of her prosthetic legs caused upset to the children. So, I mean, in terms of it, it's right to say that she didn't herself set out, these are the relevant facts I rely on. And we say there's a pretty good reason for that if one looks at the process of the review, because it was never suggested to her or put to her. It was a minded to letter. It doesn't say to her, I'm not convinced that you made genuine inquiries about your accommodation. I'm not convinced you made any genuine inquiries about your employment. That simply wasn't put to her in advance of the review decision. And she was unrepresented at the time. And essentially that's one of the issues this court has to deal with. In those circumstances, and as I say, we say the answer lies in O'Connor and F in Birmingham, that where the primary facts of the case point to the fact of the application of section 1912, then it's incumbent on the authority to look into it. And we do say they ought to delve into it, whereas we say that didn't happen here.
Yeah, I mean, you say that, but after the minded to find letter, she was asked to make representations, or she was invited to make representations, as indeed the regulations require. The time for those representations was extended twice. She did make representations on the last day of the extended period. And even after that, the reviewing officer sent her a questionnaire which asked her, amongst other things, what plans did you make before coming to the UK for housing and work?
Well, indeed.
And all she said was she had a family to help me, her sister was going to find a job, and she had a job and a friend to stay with. That's it. There was no plan.
Well, my lord, the issue is whether it's more precise than that if one follows the guidance. What that she ought to have been asked is, what one might not put it in the way Lord Cornwall puts it, but she ought to have been asked, what investigations did you make, A, in relation to the job, that you would have been able to sustain the job, because we know she wasn't. Did you know what your role was to be? Was it an active role, a sitting role? Did you make any inquiries to that?
But wait a minute, because the next question she's asked is, why did those plans not work out?
Yes.
And she doesn't say, well, it didn't work out because I couldn't do the job. She says, I never thought my disability would affect someone's psychology where I was staying.
Yes, but that's in relation to the temporary accommodation.
No, what plans did you make before coming to the UK for housing and work?
Yeah, well, my lord, I think one also has to bear in mind 2 points. One, English isn't her first language. 2, that she wasn't represented. And I think there is an important point in this case. And as I say, I'm very happy to go through the facts first, because I think it's important that in great short order we look at that, because in my submission it's simply not fair in the review decision to say you didn't make genuine inquiries without saying to her what inquiries did you make. But what I propose to do is just go through what we say about where the authorities take us,
right,
including Trindade, if I may. So
have I got this right? The relevant fact is that she would be unable to sustain the employment at Rainbow Meads.
yes, the relevant fact is that when, on the face of it, this could be a relevant fact, but it wasn't explored by the reviewing officer, that when she left the accommodation in Switzerland, she considered that she had accommodation she could stay in, and she also had a job she could go to, and she would be in a position to look after herself. It's all tied in with the homelessness application, these cases, because, as I say, she had a plan that would mean that she wouldn't apply as homeless. And that plan fell apart, as it did in a number of cases we refer to. And the question is whether or not there was something that could amount to a relevant fact in terms of the prospective employment and the prospective accommodation.
Well, I think your answer to my Lord's question is not that her inability to sustain the job was a relevant fact, but that it might have been.
It could well have been a relevant fact.
It could have been a relevant
Yes.
fact, and the reviewing officer was at fault for not having focused
Yes.
on the question whether that potentially relevant fact was indeed a relevant fact.
Indeed.
So
My Lord is absolutely correct. That's
right.
as far as our case goes.
So the focus of the appeal then is squarely based on the local authority's obligation to make inquiries.
I think one can put it in terms of an inquiries case, and the other side referred to Cramp and Hastings, which is a world apart in terms of the duty to make inquiries. It's more the situation where there is a statutory duty under Section 19, statutory questions to be answered under Section 1912, and there is guidance as to how those questions are to be answered. And we say, if the primary facts put you in the bracket of persons who could be protected, then the duty of the reviewing officer, particularly where someone's not represented at the time of the review, the duty of the reviewing officer is to engage with that fully and properly.
So just let me write this down. Now, this is what I've written down. You tell me if I've got this right. If the primary facts put you in a position where you could be protected, the reviewing officer's duty is to engage with those facts fully and properly.
Yes.
Yeah, right.
So, turning, my Lord, to the authorities bond.
Yeah.
As I said, it'll be a quick trip through the cases, but I do think it's important, given the issues that arise. The first case is tab 3, the case of Lucy and Lucy, and I think it's Mr. Justice Roth was the judge in that case. And that was a classic case where the applicants in that case, in fact, agreed to move to Turkey to go into business in relation to dog food manufacture, which I don't need to go into the factual detail, but in the judgment at page 269.
Well, we need to just look at the facts of it.
Of course.
If we go to 264,
Of course.
first complete paragraph, this is what the applicant said.
Yeah.
It was their intention to obtain permanent and suitable accommodation in Turkey, if and when the first applicant's earnings from the business permitted them to do so, and then they could have stayed with the first applicant's parents. The business didn't work out, so they had no money, so they couldn't find the accommodation.
Yes. And it was held that the prospects of employment, which need a person, I'm looking at 262, subparagraph 5, need a person to cease to occupy existing accommodation in the belief he will be able to afford suitable permanent accommodation for himself and his family is capable of being a relevant fact.
Yeah.
And then
There are two parts to that, then, aren't there?
Yeah.
That it's the belief that that person will be able to afford suitable permanent accommodation. That's the test.
Well, I think there may be a difficulty with permanent because there's a lot of references in the early authorities.
Say settled, shall we?
Well, again, there's a difficulty because there's a lot of references to settled accommodation, whereas then we had a WUA, which said that accommodation under Part 7, effectively, when the references to accommodation doesn't necessarily mean settled accommodation. So if you're in temporary accommodation and you smash the place up and you get evicted, you can't say, well, it's not settled accommodation, so I'm not liable under Section 191. So the concept of settled accommodation has been confined to where you've been franked with having made yourself intentionally homeless, and you then can reapply. So there is no reason why, if someone moves for a job, says, well, I'm going to live in a hotel for 6 months, and then I'll have enough money to rent accommodation, why that doesn't suffice. And I think the only other thing I'd flag up is the two sideline paragraphs at 269, which my learned friend sidelines in reference to section 63, as it then was, as to whether relevant facts are confined to those facts which relate to accommodation being left or accommodation to be occupied.
Sorry, where are you reading from?
It's page 269 of the authority.
Oh, I see. Yes.
Second, it's a sideline paragraph.
Yeah.
And it does say there, my lord, the last part of the sideline paragraph, it relates indirectly to accommodation being moved to, and it relates indirectly to the act of leaving the existing accommodation because the person concerned believes that he will be able to afford suitable accommodation for himself and his family by reason of the employment or business opportunity. And then the other paragraph sidelined at 270 is the off-stated paragraph that has been approved by the Court of Appeal. So there is and this is to do with good faith. So there is a distinction between honest blundering and carelessness on the one hand, where a person can still act in good faith and dishonesty on the other, where there is no question of that person acting in good faith.
Yeah.
And the next case was the case of Ciftci, which is tab 4, where the Court of Appeal sanctioned that approach. And one can observe from 727 the facts that this was a case where the applicants had been living with their parents-in-law in Bangladesh, and then they returned to Britain with their children, went to live with the parents. Applicant's father gave them notice to leave. And that was a case where it was effectively held that they acted on a wing and a prayer.
Yeah. I think wing and a prayer comes from a different case, but never mind.
I think it does, my lord. Again,
what she said at 728.
Yeah.
My plan was to stay with my parents until such time as I could afford and find suitable accommodation for my children and myself. Expected to be able to find employment without any great difficulty. And she was told by her parents that there would be no difficulty until she could find her own accommodation, no deadline. And then on the next page she says, unfortunately things didn't work out. Couldn't find employment.
Indeed, and the second penultimate paragraph on 732 effectively confirms that. The last second penultimate paragraph, 732, where the President sets out alleged honest belief that she would not experience difficulties in finding work and suitable accommodation, cannot say it was a relevant fact. It's dressed up in argument by saying she was unaware of the economic situation in this country.
So where are you reading from?
It's page 732.
732. This is Lord Justice Staunton.
Yes.
Yeah.
It's the second last paragraph. It starts with, here it is said.
Oh, I see, yes.
So there's reference in a number of these cases to the dividing line between someone, and on relevant fact, it's been said that it's acting on hope, aspiration, or a wing and a prayer. And then we've got what's said about good faith, which is shutting your eyes to the blindingly obvious, or acting dishonestly. So one can see that in that case, in contradistinction from the facts here, there was no accommodation, there was no job, there was nothing. And as I say, one can amply see how on the findings of fact made, and there are detailed findings made, that the applicants were acting on the wing and a prayer.
How does Ciftci differ from this case in terms of accommodation? The applicant in that case case went to stay with her parents, no deadline put on it. The applicant in this case went to stay with a family friend. So in terms of accommodation, they're absolutely on all fours, aren't they?
Well, it's similar. I mean, it did come before the seminal judgment in Obeid, and one could say, and as I say, I don't know if it would, I don't know if the facts would in any way support it. I don't know whether there was some genuine inquiry as to how long they could stay with the father, for example.
Well, she says, I think, doesn't she?
She said there was no deadline put on
No
it.
deadline.
No deadline. Well,
There would be no difficulties in me staying with them until such time as I could find my own accommodation, no deadline. So that's the bottom of page 728. So that was the evidence. That's what she said.
well, yes. It obviously wasn't argued in the same way, but I mean, I think the other feature of these cases is that if the reviewing officer applies the guidance, then, as we know, said by learned friends, their assessment of the facts is for the reviewing officer. So one could still perhaps categorise that and say, yes, it's still a wing and a prayer situation. I think you could have other situations where firm assurances are made, where you could argue that will amount to a relevant fact if those assurances are swept aside.
Yeah.
My Lord, we then come to the case of Obeid itself, tab 5. And that was a case where one can see from page 390, paragraph 2, Wandsworth had in fact offered the applicant accommodation, and before moving to that accommodation, the applicant found preferable property, and in the private sector for a rent of £210 per week. The applicant made inquiries with friends and relatives who lived in the same area and satisfied herself that the rent for the property would be met by housing benefits. So there's some inquiry of friends around. What one could argue that that's a very poor inquiry. It's not contacting the local housing benefit office and checking what the limits are on housing benefit.
But at any rate, the fact here was she made inquiries, she was told the housing benefit would cover the rent, it didn't,
And
so she built up arrears, so she was evicted.
She was evicted. And in the case, as my Lord knows, Lord Cornwall took the trouble to review the authorities up to that point.
Yeah.
And again, I'd highlight the fact that at page 394, the sideline paragraph, we've got this subsection is not without its difficulties. It is to be noted the test is not reasonableness of the applicant's actions, but whether they are taken in ignorance. This may seem unjust. A person who takes the trouble to find out all the relevant facts, but makes a reasonable but mistaken judgment cannot apparently claim the benefit of the section. A person who makes no inquiries at all and therefore acts in ignorance may be able to do so. The omission of a test of reasonableness has been criticised by the courts. And then at 395, there's then a review of a case which is off-cited and continues to be cited, including in Trindade, the case of Tranquil, which involved the applicants had left settled accommodation to take over an inn. And I think there was an issue that there was very poor records as to the prospects that would be a business success. But in that case, it was held that they were entitled to the protection, because I don't think it's very clearly identified, but they'd made some inquiries in terms of the prospects of the inn succeeding.
Yeah, but the essential link was that they expected the profits from running the pub to clear their debts and to be able to stay in the pub, having cleared their debts. And because the business failed, they couldn't.
Of course.
They lost their original house, and they had to leave the pub.
Indeed. But I suppose in terms of some genuine inquiry, apparently there was no records as to the profitability of the pub.
What I'm getting at, Mr.
Of course.
Fitzpatrick, is not so much the inquiry as the causative link between the job and the homelessness.
Well, the causative link, my lord, is that if someone moves and they've got accommodation that they can stay in, but they've got a job, they're in a much better position to deal with the vicissitudes where they have to leave the accommodation. They can build up a deposit. Many private rented landlords will not engage with those who are on benefits. Whereas if you're working, and this is a person in our case who had a history of working for 13 years, they're in a much better position. Now, had the reviewing officer grappled with the issues, the reviewing officer might have come back and say, well, I don't think the employment prospects make any difference. But in my submission, that simply didn't happen.
Yes.
The issue wasn't interrogated. So then we come, my lord, and I won't go back to Tranquil. Your lordship's clearly very aware of the way the decision was taken there. But at page 398, we've sidelined what is the guidance which has been followed since. The effect of those, it's a sideline passage at the foot of the page, the effect of those judgments, I understand them, is that an applicant's appreciation of the prospects of future housing or future employment can be treated as awareness of a relevant fact. So, prospects of future housing and future employment, provided sufficiently specific, and here it is specific, and it relates to specific employment or specific housing opportunities, and provided it is based on some genuine investigation and not mere aspiration. So that's quite a low threshold. So if you made some investigation as to your accommodation and as to your employment, and it must involve being able to sustain the employment, that gets you in the territory of protection.
Yeah. Right.
And again, my lord, at 399, the third paragraph, starting with no further reference, it refers to the fact that the applicant had acted in a genuine belief that she would have no difficulties with housing benefit. This was a genuine belief that I find it difficult to see why it should not be regarded as a relevant fact, just as the belief of the Tranquils as to the prospects of the inn business. If the authority thought they had made no genuine investigation of the matter, their stated belief might have been dismissed as mere aspiration.
Yes.
In chronological order, in fact, the next case is O'Connor at tab 7. And what one can see from 602, that, my lord, it's a very different case. It's not about prospective employment or accommodation. At H9 on page 602, the facts are set out, but essentially...
They left a friend to pay the rent and he didn't.
Yes, they went to Ireland and the visit became extended. There was a Mr. Walton left in the property who didn't pay the rent. On appeal, there was issues on causation as to what was the actual cause of their homelessness. Because when they came back, there was a possession order, and they tried to avoid, and they paid off a lot of the arrears. But in the event, they were evicted. So causation was found to go back to that time when the rent arrears accrued. But importantly, in the case, it was held. As we can see at 603 H20, for an act of omission to be treated as deliberate, it is not necessary for the ignorance of the fact to be reasonable, and that's confirmed. And the dividing line is the point of the applicant. Ignorance of a relevant fact is due to his own unreasonable conduct. And this case is important, we say, because it deals with the question of the responsibility for addressing the statutory questions posed under section 1912. And if one goes to page 613, paragraph 25, sideline paragraph, it is clear, first of all, from section 191 and 2, that nobody may be presumed intentionally homeless. Local authority must be satisfied of intentionality if they are to refuse assistance. This does not oblige them to make endless inquiries, but even where the applicant's case has been put, as it was here, by competent solicitors, without mentioning the statutory test. So in O'Connor, they had solicitors and they didn't raise the statutory test in their representations. It does not absolve them from the duty to ask and answer on whatever material they have the questions raised by the statute. And we say the statutory language makes that very clear.
Yes, but if you look at the review decision, which is set out at 607 to 608, it's quite clear that the reviewing officer never asked whether the O'Connors were unaware of a relevant fact, and never asked, if that is the case, did they act in good faith?
Of course.
The reviewing officer in this case posed both those questions. So you can't say the reviewing officer failed to pose or answer the questions.
Well,
you say that the reviewing officer didn't make adequate inquiries before answering the questions, but that's a different point.
Well, I think I'd reserve my position on that until we've looked more closely at the facts, because I don't think that's the case, essentially. But we'll come on to that. But yes, I appreciate that it's categorised as a decision which it takes an overview of the conduct and says, you know, you've acted unreasonably and therefore you're intentionally homeless. So, but what it is significant that the court refers to, you know, that the requirement of the statutory test, and then we've got the paragraph at 614 that we both sidelined, and I think again this is important when one comes to view the particular circumstance of the case. It is no doubt the harshness of 191 which fixes people with the unintended, unpredictable consequences of what may have been perfectly reasonable and prudent acts, although the other authorities refer to them as being not necessarily such they could be careless and imprudent. It does so, however, not by breaking the chain of cause and effect, where the effect was unintended and unpredictable, by qualifying the deliberate act which has produced the effect, refers to the analysis in Roof. It subtracts from the category of deliberate acts and omissions those done in good faith, ignorance of relevant fact. It imposes no requirement that such ignorance must be reasonable. Any relevant fact must include, if it is not confined to facts which in the event have brought about the applicant's homelessness. Secondly, willful ignorance at least must fail the good faith test. And then at 34, there's reference to the judge's finding, like the review decision. This is at page 615 and it's sidelined. Makes perfectly good common sense, but it does not reflect the test set out in the statute. And again, it refers to the fact that there's no qualification for the word unaware, and a person's ignorance may well be due to their having behaved unreasonably, but they do in consequence. But what they do in consequence may still be done in good faith. The statutory dividing line, as it seems to be me, comes not at the point where the applicant's ignorance of a relevant fact was due to his own unreasonable conduct, but at the point where, for example, by shutting his eyes to the obvious, he can be said not to have acted in good faith. So I think on the good faith side of the test, as it were, under section 1912, shutting your eyes to the obvious or willful ignorance, and then we get what Lord Justice Lloyd summarises that in Ugabi.
just as a matter of interest, what's the status of this judgment?
Well, it's interesting
Because Lord Justice Carnworth agrees that the appeal should be allowed for the reasons given by Lord Justice Waller.
Indeed.
And what Lord Justice Waller says, at paragraph 54, was to ask whether the decision maker should have looked at section 1912 without prompting. He says yes.
Indeed. I think the status is that since what is said by Lord Justice Sedley has been referred to and adopted in Ugabi.
Right.
And I think, I'm not sure about Trindade, but we'll come on to that.
Yeah.
But yes, I do understand the point that the majority, it's Lord Justice Waller's more precise, as it were, way in which the appeal is allowed. And I was going to come on to that paragraph because that also, in my submission, assists with our approach in the case, which sets out that the question comes down to, in my view, to asking whether the decision maker, having concluded that the 16 months of failure was causative, should have then looked at section 1912 without any prompting from the solicitor. It is somewhat harsh on the decision maker that he should not be able to rely on a solicitor's letter as indicating the issues. That is what has given rise to my reluctance. But in my view, this case, he was bound to do so in the light of the facts about which he had been told.
Yeah.
So,
before you leave that case, we go back to paragraph 30. Lord Justice Sedley says at the bottom of the page, any relevant fact must include, if it is not confined to, facts which in the event have brought about the applicant's homelessness. Is it confined to facts which have brought about the applicant's homelessness?
well, I think. I mean, this case was. I think there's a special category of cases. It seems to be whether it's justified or not, dealing with prospective employment and prospective accommodation, and if one says that it's confined to the facts which in the event have brought about the applicant's homelessness, clearly in this case, it was confined in that way because the applicants were in Ireland thinking that Mr. Walton was paying the rent. But if it's been said here that one must confine the approach only to the facts that bring about the homelessness, I don't think that's sustainable if one looks at OBEID and the other authorities on prospective employment and prospective jobs, such as Tranquil.
Thank you.
So, as I said, it was taking the cases in chronological order. There's then I add in at tab 6.
Yeah.
And again, I don't need to say much about this case, but paragraph 2 sets out the circumstances of it, and it's clearly a wing and a prayer case. It involved a scientist who was on a fixed-term contract working in Belgium. He had come to the knowledge of the UK. He had been in the UK in 2002. He came to the UK in search of work in June 2003, staying initially with a friend or relative. And effectively, it was argued there, and one can see it from paragraph 6 of the judgment of Lord Justice Morris Kay. The second part of paragraph 6, the case for the applicant was that when he gave up accommodation in Belfast, in Belgium, he was unaware of a relevant fact, namely the true prospect of being able to find suitable work in the Birmingham area. And it was found very firmly that this was on the wrong side of the divide. The only further point from this decision...
Hang on, you need to read the rest of the sentence. And with it, the means to pay for suitable accommodation.
Yes. Yes.
Yeah.
And I suppose what's significant is this is a case where one can see at paragraph 11 that the approach of Cornworth J, as he then was in OBEID, is adopted.
Yes.
And in relation to the question of inquiry, and it is at paragraph 12, subsection 2, there's reference to O'Connor, and there's a reference there that 6 lines down. As regards O'Connor, I would simply observe that whilst there are or may be cases in which the first decision maker or the review panel may be required to consider section 1912 because the material before them renders the need for such consideration obvious, notwithstanding the absence of express reference to the subsection in the representation submitted by or on behalf of the applicant. For my part, I would not impose such a duty outside the circumstances of obviousness or circumstances in which it is plain that the housing authority has been put on warning as to something that might arise and merit consideration under that statutory provision.
Yeah.
And then to go to, I won't go to Crampton Hastings, which obviously involves inquiries into the situation of whether someone was in priority need. In both cases, there was very substantial inquiries, and then on review it was suggested that some further extraneous inquiries ought to be made, including one with the probation service. And Lord Justice Brooks used the opportunity to set out again the general approach on inquiries. But if I could, yes, go to tab 9, F and Birmingham City Council. And again, at 276, H9, H10, this was a case where it involved moving from accommodation that had been provided to accommodation that was unaffordable.
Yeah, this is another housing benefit, not paying the rent case.
Yes, it's another housing benefit. And in this case, it fell on the wrong side of the dividing line, quite clearly, because on the facts in interview, the applicant had made it clear on the facts that she had made no inquiry as to whether or not she would be able to afford the rent. And there was some discussion as to whether or not that had been the case, but effectively the court firmly found that those findings of fact were ones that had been made.
Yeah.
So in that case, there was a proper interrogation of the facts in terms of affordability. But and one can see that from paragraph 15 of the judgment.
Yes.
But the paragraph I'd refer to is 17, because there, Lord Justice May refers to, and in fact summarises some of the cases, and sets out that in conducting a review, a local housing authority is obliged to consider section 192, even if it has not been specifically invited to do so, if it is sensibly capable of arising on the facts. An applicant's appreciation of the prospects of future housing can be treated as awareness of relevant fact, and quote from Obede, if it is established that the applicant was unaware of relevant fact, the question is not whether the ignorance was reasonable, but whether it was in good faith. And as I say, that was a wing and a prayer case, because no inquiries had been made as to whether she could afford the housing benefit for the new property. My Lord, there's then the Ugabi case at tab 10. And what one can see from the facts at H10 that the local authority accepted that a relevant fact existed.
Yes.
It was accepted that this involves someone in private rented accommodation, whether they should have waited to be evicted by the landlord. And they were advised to go to seek advice from the local authority. They didn't do so because they thought they might be effectively required to make a homelessness application and put into temporary accommodation. But it was accepted by the local authority that ignorance, her failure to appreciate that she could not be required to leave without a court order was ignorance of a relevant fact. That's at H12. So the whole argument in Ugabi was in relation to whether or not it could be said that her being told to get advice and not doing so meant that she could not fall within the mantle of good faith. And one can see from paragraph 10 that there's a very extensive review of all the authorities, including O'Connor.
Yeah. Can I just ask you about paragraph 6? Last sentence. Admittedly, Lord Justice Lloyd is dealing with good faith rather than relevant fact, but he says the good faith applies to the act or omission and must be in some way related to the statutory consequence, that is to say, whether the person is or is not to be treated as intentionally homeless.
Yes.
That would apply to relevant fact as well, wouldn't it?
Well, effectively, because subsection 2 effectively provides an exception to subsection 1. So yes, it would apply. And in terms of the conclusions, having extensively reviewed the authorities, that's what one has at the top of 610. One can see at 24, Mr. Broach for the local authority was arguing that willful ignorance is not limited to Nelsonian example, where a person is treated as knowing that which he would be told if he had asked. But that approach was rejected. And at 27, again, we've got the judgment that has been adopted in the further cases, and it's of importance so far as good faith is concerned. And it sets out, and it adopts the reasoning of Lord Justice Sedley and O'Connor, and sets out, I'm looking at page 610, 27, the sideline passage. Good faith carries the absent good, well, it seems to me that use of the phrase good faith carries a connotation of some kind of impropriety or some element of misuse or abuse of the legislation. It is aimed at protecting local authorities from finding that they owe the full duty to a person who, despite some relevant ignorance, ought to be regarded as intentionally homeless. Its statutory purpose is analogous to subsection 3. Dishonesty is the most obvious kind of conduct which it would catch, and willful blindness in the Nelsonian sense comes close to that.
Yes.
So, I mean, in this case, I think, and I think there's problems with transcription, but I think at first instance, His Honour Judge Hellman actually puts it that if we'd established an issue of the relevant fact, he would be minded to find that effectively, well, it wouldn't be for him to find, but I think he would have been with us on the issue of good faith. I mean, we say in terms of good faith, one applies that approach, and one considers the very unfortunate circumstances of the appellant at the time she made the decision to give up her accommodation. It doesn't fit, certainly doesn't fit in the impropriety category, and in my submission, given that she had accommodation and a job, doesn't fit within the shutting her eyes to the obvious or willful ignorance.
Yeah.
My Lord, I'm not going to trouble the court with Holmes Moor House, which again does not relate to section 1912, but obviously contains the general...
It tells us how to read review decisions.
Of course. And obviously one looks at the whole of that passage as to what it says. The case of Najim and Enfield, I don't propose to go to. It's a case where, rather unusual case, where the tenants withheld rent because of failure to carry out repairs, as at common law they may be entitled to do. It's very dangerous if you hold an assured short-hold tenancy. And in the event, the landlord brought possession proceedings. I think there was 2 reasons given, but ultimately it was found that the reason was because they withheld the rent.
Yeah.
And they didn't fall within the protection. And That is a different category of case because it doesn't involve prospective employment or prospective accommodation. So the final case, which I know my Lord is very familiar with, is the Trindade case at tab 13.
Yes.
And again, that is a case of the applicant. We see from H11, the applicant lived with a partner and children, rented flat in Sao Tome in Africa. Daughter was disabled and came to the UK. And page 13 sets out, the authority decided, homeless intentionally, the appellant requested a review of that decision. The authority's reviewing officer upheld the decision, concluded the applicant had left Sao Tome based on little or no information about London and the accommodation that her sister would be provided. And it was held there that the case is on the wrong side of the dividing line and there was no relevant fact. And it's significant there in the judgment of Lord Justice Sales, paragraph 10, there's an excerpt from the reviewing officer's findings. And if one looks at, as I say, paragraph 10 of the judgment, but at the indented paragraph 33, I find your assertion that your client had taken to stay with her sister for more than a fleeting amount of time surprising, since she had not agreed with her sister how long she could stay until after she arrived at her sister's address. Your client admits that she did not know how London is, and she'd just been advised that there are good medical specialists here who could treat her daughter. At the time your client left Uba floor, she had no clear understanding from her sister about how long she could remain with her. The intention of the accommodation was to last only until your client's daughter was well. This arrangement has the seeds of its own destruction. So it's clear that in that case the reviewing officer did grapple with the issue to hand. There was no employment, but there was some accommodation made available. And it was found if one looks then at just give me a moment, I've lost my place. Yes, we then have the detailed discussion from paragraph 20 of unawareness of any relevant fact. And again, at 23, the sideline passage sets out there's reference to Nugee, and there's reference to the top of 641, an active and informed understanding of the applicant at the time she does or admits to do something within the scope of section 1911 of the current prospects in relation to expectation working out as anticipated, where in fact, as judged objectively at that point, there is no good foundation for the applicant's assessment of those prospects. It refers to the authorities and then adopts at 25 the approach of Cornworth J, as he then was in Obeid.
Yes.
And essentially, at 26, again, it refers to an active belief that a specific state of affairs would arise or continue. You've got a job and you continue to be able to work. On genuine investigation about those prospects and not mere aspiration. And it was found that this case fell on the wrong side of the dividing line, that there was no this was a case where it was aspiration. And then over the page, the court then deals with good faith. And in relation to that, my lord, I would say that it's obiter, having found that there's no relevant fact. It's obiter. But again, one can see that at 33, on page 643, the judgment of Lord Justice Lloyd in Ugabi is adopted. But at 35, there is a reference to 3 lines down. However, in my view, if she left with reckless disregard of what her housing prospects would be in the UK, I mean, in terms of good faith, we say the approach is well established. That when talking about shutting your eyes to the obvious willful ignorance or dishonesty or inappropriate behaviour, recklessness is difficult because, in fact, the whole, as has been set out, there's no reasonableness requirement. An imprudent behaviour, honest blundering, can be protected.
But I mean, on the facts of Afonso, the applicant had somewhere to stay when she left San Tome. She was going to stay with her sister. What she said she didn't know was that her sister's tenancy was liable to be terminated.
Well, I think what's found is there was little or no information garnered from her. There was little or no inquiry made. I mean, it's set out there in the judgment 33.
Yeah.
Yes, but the difference between this case and Trindade is that the quality of the reviewing officer, the reviewing officer grapples with the issue.
I makes it. We're back to the scope of the inquiry.
Indeed. So, my lord, that's what we say as to the authorities, and then if I could then come on to the actual the relevant facts of the review, and in my skeleton argument, page 5, I've summarised the situation as to the narrative.
Yeah.
I mean, it's just to summarise it, we know that the appellant, and it's referred to as worked as a radio producer. It's also referred to as radio operator, but we know that she worked for some 13 years in a job in Switzerland. We know she was off work for 2 weeks between the 19th and the 30th of November 2018. And we know that she left her job in December 2018. And we know that she lived at 44 Manston Adams Road from the 30th of January 2019. Mm-hmm. And from the 11th of April 2019 to the 1st of August, she worked at Rainbow Meat. And so then in terms of the inquiry that was carried out by the local authority into a situation, and I'll just highlight a few documents which we say are significant. But at 28, going to the supplementary bundle,
yep,
one can see that there was a telephone call on the third box down, 9th of October 2019. There was another phone call to her employer trying to find out why she had left, and I would presume, and it said she was helping the accountant, and she was not capable of doing the job because she could not stand up for long periods of time due to legs. As per mutual agreement, she left, and it's not quite the same thing as what she says in response to the questions. I don't know if things have been lost in translation, but that's the information they had at that point. So then at 45 of again the supplementary bundle, there's an email from the appellant herself of the 24th of October 2019.
Sorry, which page?
It's 45 of the supplementary bundle.
45. Yeah.
And it refers to, you previously mentioned interview, believe I can be intentionally homeless, strongly disagree. And yes, I've moved from Switzerland, surrendered my property. Outcome was unfortunately not always as the way it was expected to be. Child suffering. I've had to make a tough decision. If I was a healthier person, I may have been able to handle homelessness situation better. May not have had to come to the council, knows. But I have had no other option. If I had surrendered my home and come to the council, fair enough for your comments. However, this is not the case.
Yes.
Then we have the section 18, the section 184 decision at page 180 of the main core bundle. And my lord, the only significance of this really is that it doesn't go into any detail to do with the fact of her having a job and having accommodation. It sets out at 181, third paragraph up from the bottom. Came to the UK without an arrangement to stay, temporary basis, as you were unable to stay with your sister due to overcrowding. This indicates to me that you did not make adequate arrangements for living in the UK before surrendering your tenancy. And noting I consider the decision to be willful and reckless at best. And on 185, in relation to relevant fact, the only comment under the heading was the applicant unaware of something relevant. I'm satisfied that you were fully aware of the need to seek advice and apply for any welfare benefits available to you in Switzerland to sustain your tenancy. I therefore believe that you're not aware of any relevant facts. So relevant facts as they relate to accommodation or particular employment are not being set before the appellant for her to address.
Well, what about 183? Other issues raised.
I'm sorry, my lord.
183, other issues raised.
Yes.
You advised you were employed in Switzerland as a radio operator. You left. You provided a medical certificate which showed doctor signed you off in 2018. Doesn't suggest you were unable to continue with that employment. Sickness temporary. So the job at Rainbow Meats, this wasn't something that was raised.
Well,
This is the Swiss job.
No, yes.
Yeah.
This is the officer at first instance reaching a
Yeah, I
decision.
follow.
They know about the job at Rainbow Meats, and they know
Yes.
that she was in accommodation. In my submission, once they knew that, they ought to have considered it as to whether or not that fell within a relevant fact under section 1912. The focus here is essentially you made a bad decision. You shouldn't have come to the UK without securing proper permanent accommodation.
Now, I may not have quite got this right, so correct me if I'm wrong. But what I have written is, once the authority knew that the appellant had left the job at Rainbow Meats, they should have investigated whether there was a causal link between loss of that job and homelessness. Is that the essence of what you're saying?
Well, I think the essence of what I'm saying is that once they knew, they knew that, yes, they knew when she made her homelessness application that she'd had a job when she left Switzerland. So once they were aware that she had a job when she left Switzerland to go to, an accommodation.
That's the job at Rainbow Meats.
Yes.
Right.
That is something that, in my submission they had to engage with.
But what, and you say engage with, but what's the question that they're asking?
Well, they're asking whether or not, as a result of that prospective employment, which you actually took up, there was a relevant fact she was unaware. And it comes back to this issue of, had she been able to sustain a job, she would be in a much better position in terms of her housing situation when she had to leave the temporary accommodation.
Yeah, well, isn't that what I've said? You had to investigate whether there's a causal link between her loss of the job and her homelessness. If she'd been in a position to rent somewhere,
Yeah.
having been asked to leave the sofa bed, then...
Well, I think my only concern is the reference to causal link, because causality in terms of these cases, I mean, causality in terms of being found intentionally homeless has been, it's well ascribed in various judgments. But in terms of it's a different concept. One's looking at the question.
All right. Well, I'll cross that out, and I just want to understand, what is it that you say the housing authority and or the reviewing officer ought to have investigated?
Yes.
What was the question?
The question
that should have been posed.
The question should have been posed is whether or not she fell within the protection of Section 1912.
Well, I know, but that's just restating. I mean, what is it?
On the
what is it there
basis
to investigate?
that, as to whether or not she had made any genuine inquiries, some genuine inquiries, as to whether or not the job was sustainable, given her handicap. And I also say they ought to have investigated whether or not she had made any genuine inquiries about her stay at 44. But the main plank is really in terms of the employment. They could also have made inquiries and said, well, actually, yes, we don't think the job, if you'd stayed in it, would have made any difference to your homelessness.
Well, so suppose they had investigated, and suppose they had concluded that your client had made genuine inquiries about the sustainability of the job.
Yeah.
Right, that's where they get to. So she was unaware of that fact.
Yeah.
What's its relevance?
Well, if she's unaware of that fact, then she falls within the protection.
Why is that fact relevant?
Because it's relevant because she has employment that, had it been sustainable, may well have created a continuing situation where she would not have to apply as homeless.
Right, so it is connected. Causative
Yes.
link, you don't like that phrase, all right. It's connected
Yes.
in some way to homelessness.
It has to be connected to homelessness, yes, because her plan was that she would make a homelessness application. And all the cases talk about, in terms of prospective employment, where those plans have gone awry because of something you didn't know, or not at least any relevant fact.
Yeah. Right.
Just in terms of what's been said about whether she was represented on review, taking it very shortly, there's an email at 51 from solicitors of the 6th of February.
This is where they say they're no longer represented.
Well, the first email says they're acting for her on review. It's in Supplementary Bundle 51. So they're going to act for her on the review, and then there's then a letter that deals with accommodation pending review, and the point made there is there's been no representations made at that point. That's a letter at 56 of the 4th of March. Mm-hmm. So they say, well, you haven't made any representations to say why the decision's wrong. More importantly, at 59, there's a minded to letter issued by Terry Schiff, the reviewing officer. And if I can invite the court's attention to page 60 of that. So this is informing the appellant that this is the way the reviewing officer sees the case. And paragraph 4 on page 60, that in considering your reasons for voluntary leaving and moving to the UK, it's apparent that you made no sufficient plan to obtain settled accommodation. Again, we say that's misplaced.
Misplaced in what sense?
In terms of that is not the statutory test. You don't have to obtain settled accommodation.
No, all right, but what the reviewing officer, what the decision maker is saying is you made no sufficient plan. She says, putting an issue, what plan did your client make?
It says to attain settled accommodation. The reviewing officer comes back to this in the main decision, and this is, I would suggest, and obviously it's your interpretation that matters, but I suggest that the reviewing officer is sidestepped by considering this whether or not the accommodation was settled or not, which I say, or we submit, that it doesn't have to be settled accommodation, provided you've got a plan that you've genuinely investigated with regard to accommodation and employment. And then there is reference to the Trindade case, and it refers to the passage in the Trindade case, section 191, genuine belief that a specific state of affairs would arise or continue in the future. In leaving Switzerland, you moved into friends' accommodation, which is not viable. So there's no reference to the employment situation. And then paragraph 7, by your reckless action in giving up your settled accommodation, which was reasonable and available for you, and obviously that's a finding under section 191, subsection 1, that accommodation has to be reasonable to continue to occupy. Coming into the UK on a wing and a prayer, you did not act in good faith, and you were only unaware of relevant facts due to your own lack of planning or investigation. And we say that that's a muddled approach to what's required under the statute and what's required under the guidance.
In the preceding paragraph, the decision maker says, this shows you had not made adequate arrangements or investigation of the housing situation in the UK. So the question of investigation is raised.
Yeah. I accept it in the review decision, it refers to inquiries, but in a very general way, which we say is inadequate in the context of the primary facts here. So that's the minded to decision. We then see that Virgo and Co. at 62 well, there's a short email of the 15th of May to say they're no longer acting. And then there's reference at 64, an email from the appellant of the 27th of May, where she says she's trying to find new solicitors.
Yeah.
And
so the chronology here, if we go back to 61, sorry, 60, submissions are requested by, right at the bottom of the page, submissions requested, representations requested by the 1st of April 2020. Nothing happens. In May, the housing authority has told the solicitors have failed, are no longer acting. 27th of May, she's allowed till Friday to provide information. And that seems to be more or less on the same day. She replies, bottom of page 64, trying to find new solicitors, and on the following day, the reviewing officer says, you've had an extension, you must send me something to consider by tomorrow.
yeah,
So we're now nearly 2 months after the original deadline.
yeah. I mean, my lord, there are cases where these review decisions can take a year.
Oh,
There's
yes,
very
no problem.
extensions for medical report or for further
Yeah,
information.
no, I'm not suggesting otherwise.
Indeed. The representation she made are at page 66.
Yeah.
Which essentially set out her circumstances, and she said she wasn't capable of managing her affairs, and that she refers to in the second last line, therefore the decision to give intentionally homeless for my decision to give up my tenancy in good faith to get needed support is wrong. She obviously doesn't address any relevant fact that she might have been unaware of, but that's, as I say, in my submission, it's not really been put to her. So then we get the questions which were asked on the 29th of May, page 67.
Yeah.
And there is reference at page 68, the bottom email. There's reference to an interview by phone at 3 p.m. But as I understand it, no interview took place. There's certainly no record of any interview.
Yeah.
And my Lord, we then come on to the responses which your Lordship raised earlier at page 70. And I mean, I'll just go to the relevant questions. But one, she's asked what type of work she did. Switzerland radio producer. Two, how did this work end? Did you resign? And then she says, due to my disability, I was a victim of mobbing at work. Suffered severe depression, not able to do the work properly. And then the question, what event made you plan to come to the UK? Refers to a disability, unemployed, for mental health, and spoken to my sister. She found a job at Barron Meat and to stay with a friend. I come to London. So there's no detail given there. She's asked at 6 about her eldest son, but at 7 she's asked about social care and assistance. Then at 8, what plans did you make before coming to the UK for housing and work? I knew I have a family to help me and my sister find a job for me before I come to the UK. I knew I have a job, a friend to stay with, and family to help and support me. And it's accepted there's no detail given there. Why did those plans not work out? And the response to that is never thought my disability would affect someone psychologically. Where I was staying, my friend said, because when I take off my prosthetic leg, I walk on my knee, her children psychologically is the effect of my walking. So that's part of the plan in relation to accommodation. And then she's asked at 12, what work did you do in the UK? And she refers to Barron Meat, and I was arranging files, speaking to Turkish customer, because most of the customers were Turkish. So, as I said, the reference when the local authority phoned was that she was assisting the accountant, and she's saying she was doing some filing. And then how it refers to the dates. Why did you leave this job? Because my hand was swollen, and I was not well. I have been sacked.
Now that's a curious answer, given that she says now that she couldn't stand up.
Well, essentially this is what she said. She submitted with that email. She submitted some attachments, and the last attachment is a letter which is dated the 1st of June from Barron Meat.
Yeah.
And says, we tried our best to keep her as employee, but she had difficult times to fulfill her duties. Please note that our working environment is not sufficient enough to accommodate her, and our job is too difficult for her to handle. Mm. So I accept it's unclear. It seems to relate to her either her ability to stand or problems with her hands. But at the point when the decision's reached, it's all up in the air in terms of that. And there is a difficulty because English isn't her first language. Yeah. It's quite clear. She put in a letter from her employee that is different from what she's saying herself. So there is a lack of clarity on that.
But if we go back to question 9 on page 70, why did the plans not work out? That's when one might have expected to say, well, I lost my job. The plan was to find somewhere other than the sofa bed. Let's not use settled accommodation. But I lost my job and therefore I ran out of money. But she doesn't say that.
Well, indeed, if it had been put to her, my lord, that in terms of the OBID approach, that in certain circumstances, a prospective employment can amount to a relevant fact if things don't turn out the way you expect. Can you tell us, first of all, it's the inquiry point. Did you make some, the first question really would be, what did you know about the nature of the job before you left Switzerland? Because it's the time of leaving Switzerland that's important. Just giving up the accommodation. And it would be interrogating that and saying, well, did she know that it was an office job? Did she know that she'd have to stand for the better part of the day? And I think what we do draw on is the fact that she worked for 13 years as a radio producer, which we say is relevant when you're considering someone's ability, despite her disability, to maintain and sustain employment. So yes, it could have been responded to more fulsomely. Clearly, if she had solicited, the expectation is that they would have provided a very full response, but she didn't. So finally, if we could go to the actual review decision, and it's in the bundle at 172.
Yep.
And one can see at 173, my lord, that there's a reference halfway down, there's different headings, and it's the last settled accommodation. And refers to the fact that the accommodation in London cannot be considered settled. Refers to income and expenditure, and there's no issue on that. Over the page, the next heading is availability of accommodation. And there's no...
Just pause. The income and expenditure form is relating to the Swiss flat.
Yes, yes.
There's no. Is it suggested that Mrs. Towson wanted to be paid anything?
No, there was no. I don't think there was any income and expenditure form to do with when she arrived in the UK at all. But we've got on 174 availability of accommodation. And then the next heading is reason for ceasing to occupy last settled accommodation.
Yeah.
And the penultimate paragraph, the question is, did you have a genuine reason to surrender your tenancy? And did you act in good faith in doing so and coming to the UK? And I don't think that's a proper summary of the statutory approach. But at this point, the reviewing officer is dealing with section 191, subsection 1. But it is significant. The reviewing officer doesn't have a separate consideration of the application of section 1. It's dealt with, it's referred to. But one would expect in a case where the evidence has been presented of job and accommodation, a separate consideration. And then it goes on at the top, second paragraph on 175, the fair assumption that sleeping on a sofa bed with a dog, with a son and dog at someone's home be a temporary arrangement. On the face of it, be reckless to surrender settled accommodation, to move your family abroad to sleep on someone's sofa bed. And it goes on to refer to a rash decision. And then paragraph 6, 175 is where we get to the nub of it. While you are within your rights to assert the freedom of movement within the EEA and move to the UK, and obviously being closer to your sister has its benefits, you would still be expected to make plans to have settled accommodation and a means of income when coming to the UK. My submission is that this does suggest that the reviewing officer considers that you can't move unless you've got settled accommodation to go to, which is wrong. But then more importantly, paragraph 7, says the job at Rainbow Meats was short-lived as you were unable to do the work because of your disability. You advised that your sister found you this job as well as the accommodation. It would seem you did not make sufficient inquiries regarding the nature of the work. So again, that's very generalised, it would seem, without making an actual inquiry, and whether you were capable of doing it. And then oddly it says, while this is not necessarily relevant to your housing situation. And we say it is something that is relevant to the homelessness application or should have been seen as such and was worthy of investigation.
Well, is that right?
Well,
It's not necessarily relevant. It can be relevant. It might.
Well,
might be
I think
relevant.
if
It's not necessarily relevant.
it's, well, I mean, the key point is whether or not applying the guidance, once you know that someone's come with a job, do you have to delve into it? And in my submission, you do, particularly when someone's not represented. If someone's represented, there may be different arguments that if the solicitor doesn't delve into it, why should you? But as I say, we say O'Connor Birmingham supports that approach. But it's clearly a matter for the court, the extent to which one draws the line. But then it sets out, having been mindful enough to comply with your tenancy agreement and find alternative accommodation to take over the contract, you then came to the UK in a wing and a prayer, expecting a sofa bed in someone else's living room, and a job you knew little about would be a suitable alternative for settled accommodation. And as I say, the key references there are to settled accommodation, but also you did not make sufficient planning. And that ignores all the authoritative guidance as to honest blundering still being protected and potentially unreasonable behaviour. It's saying effectively you've got to have a sufficient workable plan or else you're not entitled to the statutory protection. So it ignores the test of the fact that reasonableness doesn't apply, and in relation to good faith, it doesn't deal with the correct approach.
But as you said, she's the reviewing officer here is dealing with section 191. The question here, on this section of the review decision, is did you do something deliberately which caused you to...
Well, I mean, that may be the case. My reading of it is that, as I say, that's the best we really get. There is a short reference at the end of the review decision. The decision goes on to consider medical problems reasonable to continue to occupy, other issues raised. And then at 178, was the applicant unaware of something relevant? And I'm satisfied that you're fully aware of the need to find settled accommodation. I mean, that's just the wrong approach. You would know that moving into someone's living room with a child and dog would be precarious. Again, that is not the statutory test, and that doesn't meet the guidance. And then finally, it refers to what was the applicant's deliberate act done in good faith. Already concluded there was no relevant fact of which you were unaware. And it's interesting that at the minded to stage, there were relevant facts. Because the reviewing officer at the minded to stage says that the reason you were unaware of relevant facts, I better actually go to it. So that in this, the minded to letter at 59, sorry, this is in the supplementary bundle. I mean, it's the third paragraph from the bottom, paragraph 7 of page 60. By your reckless action, giving up settled accommodation, which was reasonable available for you coming to the UK in a wing and a prayer, you did not act in good faith, and you were only unaware of relevant facts due to your lack of planning or investigation. And so on good faith at 179, it says, I'm satisfied you have not acted despite being fully aware of the consequences of acting and surrendering your settled accommodation. You continued to do so. This was despite having the capability to act appropriately. So, so my Lord, we submit that if it was a case where she just left Switzerland with nothing to go to, got on a plane, said I've had enough, perhaps that level of reasoning would be appropriate. but when she puts forward the job and the accommodation, it required, we say, further proper consideration to meet the requirements of the statute, which haven't been amended, and to meet the requirements of the guidance of Lord Cornwall and O'Bede.
Yeah.
Finally, my Lord, in terms of submissions, there's a couple of other points we made in the skeleton argument. I'll just check that I've referred to them. Yes, I mean, the only thing I'd add is that in the skeleton argument refer at the end, which is at 22 of the core bundle, from paragraph 46, make reference to, as I say, the fact that an unrepresented applicant, unless told of the approach to be applied, and that's in relation to this potential significance of her employment, is not going to know what she needs to address. And I suppose it follows that if in the minded to letter it said explicitly what inquiries did you make as to whether you could do the job before you left Switzerland, then that would be...
But the minded to letter did say you didn't make adequate inquiries.
Well, the minded to letter is directed entirely at the accommodation issue, not directed at whether or not employment featured in the case. And we say it obviously does. It's a combination, because you're looking at a situation where, yes, if she just had the precarious accommodation, she'd probably be floundering. But to have both, we say, points to a situation which is much more, can be described as honest blundering, where the protection can be invoked. And yes, once it's raised, and as I say, it's specific employment, not a situation which she said, oh, my sister says she might be able to get me a job.
Yes.
Well, look, can I just turn my back for a second?
Of course.
My Lord, those are my submissions, unless there's anything else.
We'll just rise for a few minutes, see where we are.
I suspect that means you mightn't hear from me yet. I was going to say, I got a very clear impression. Yeah, I would have preferred a coronation.
By the way, I think it's still being filmed.
Mr. Evans, this appeal in the end really boils down to the scope of the housing authority's duty to make inquiries, and that's the only issue on which we wish to hear you.
I'm grateful, my lord. Well, my lords, my submissions are these, and these are the principles from the authorities on that point. Section 184 of the Act, in Divider 1, as you've seen, requires a local housing authority to make necessary inquiries. As we see from Cramp and Hastings, Lord Justice Brooke, with whom the other members of the court agreed at paragraph 10, those inquiries need not be CID type inquiries. That's at Divider 8.
Sorry, just a minute. This is Cramp, you said?
Cramp and Hastings, decision of this court
Yeah.
from 2005.
Paragraph
And
8.
paragraph 8, yes.
No, you said paragraph 10, you said tab 8.
Sorry, 10.
10.
I'm grateful, my
Oh,
lord.
I see. Yes.
Reference to ex-party Winchester.
Yes, thank you.
Well-established authority. And then in the same case, at paragraph 58, a challenge on inquiries can only be successfully mounted on grounds of Wednesbury unreasonableness, i.e. the council can only be attacked for failing to make inquiries if it failed to make an inquiry which no reasonable council could have failed to have regarded as necessary.
Yeah.
In the same case, slightly out of order, paragraph 14, Lord Justice Brooke is there remarking that there is now a statutory review procedure and an appeal to the county court. But the upshot is, given the full-scale nature of the review, this is the second half of the paragraph, a court whose powers are limited to considering points of law should now be even more hesitant than the High Court was encouraged to be at the time of ex parte Bayani, if the appellant's ground of appeal relates to a matter which the reviewing officer was never invited to consider, and, I emphasise, was not an obvious matter he should have considered. Now, that matter of obviousness comes in the case of Or Aidan, which Milena Friend did take you to, paragraphs 10 to 12. And if I could refresh your memory on that short passage.
Can you just remind me of the chronology? In the early days of this legislation, the Housing Authority made a decision, and if you didn't like it, you had to go for judicial review.
Yes, under section 60, subsection
Right.
3. If it
When did the procedure for the statutory review come in?
Same time, I would think, as Milena Friend said, I can't give you at the moment, my lord, the exact date, but when the Housing Act 1996 came into force.
Right, now I think
So that was
1997, I think.
20th January 1997, Milena Friend said. Whether or not the procedure came in exactly on that date, it was 1997 onwards.
Right.
In some sense.
So cases decided before 1997 are all cases where the first available opportunity to challenge the decision was on judicial review.
Indeed, Mark.
Yeah.
But Cramp was not such a case.
No.
And nor was Or Aidan in Divider 6.
No.
And this picks up on the thread of obviousness here.
Yeah.
And talking about the duty to look at 191 subsection 2 if it's not been raised. The Court of Appeal held that I would not impose such a duty outside the circumstances of obviousness or circumstances in which it is plain that the housing authority has been put on warning as to something that might arise and merit consideration under that statutory provision. Now, Lord Justice May in F and Birmingham cited that with approval, that's divider 9, at paragraph 17. Again, a decision of this court.
Yeah.
But use the shorthand phrase, if it's sensibly capable of arising on the facts. That I say is a shorthand way of what I've just read to my lords in relation to the O'Reilly case. So it's either got to be obvious, or there's got to be some trigger which then might lead the local authority to making the inquiry. And our simple submission in this case is there was no trigger of the kind that my learned friend seeks to posit to this court today. And that's because, as my lords are fully aware, and we now look at the facts, well, perhaps I should take two further passages. O'Connor at paragraph 25. And O'Connor is divider 7. Again, my lord's been taken to this, but
Yep.
I would emphasise the words on whatever material they have in that final sentence.
Well, that doesn't get you very far, does it? If they haven't asked enough questions
Well, that
to
is
get the material.
that is true. What comes first, the chicken or the egg?
Yeah.
Well, what I say is an appellant must give sufficient facts to trigger an inquiry.
Yeah, understand.
And that wasn't the case
Yeah.
in this particular. Then the local authority must make the necessary inquiries, the limit of which are defined by the facts as presented by the appellant to them on interview and throughout the course of the process. And then ultimately, whether or not one calls it a burden or not, paragraph 26 of Da Trindade kicks in, that ultimately the applicant has to show that they have an active belief that a state of affairs would arise or continue based on some genuine investigation in relation to their prospects, whether it's in this case, of employment or of housing. And my lord teased out, and my learned friend eventually, that there needs to be a link between the prospects of employment and the housing situation for it to be a relevant fact. So there is also again, paragraph 29 in Afonso da Trindade, divider 13. Again, my lord's been taken to this.
Sorry, which paragraph? 29?
29 again.
Yeah.
Second sentence, the assessment of the facts was for the reviewing officer based on the evidence available to him. In my view, on the facts as found by him, he was clearly entitled to decide that the appellant had not made a proper investigation of her prospects of accommodation. And we see that there's no difference here between Da Trindade and the instant case, except for we're dealing with prospects of employment rather than the prospects of housing alone, as it was in Da Trindade. So when we look at the facts in this case, we ask ourselves, what trigger is there for the local housing authority to have made the kind of inquiries which are now posited by my learned friend? Well, my lord, I'll take these at some speed because you've seen them, but please cause me to slow if there's any document you would wish to see. in the initial interview, supplemental bundle, page 27, and I'll give my lords all the references. She said, I came to the UK for support from my sister, and my health has deteriorated. It's not suggested, therefore, in the initial interview on the 7th of October 19, that she came to the UK to work and needed that work to fund future accommodation, whether permanent, settled, or otherwise, however we call it. There is mention, I accept, of her having worked in the UK for a period of 4 months between April and August 19, but that was the extent of it. Melissa is taking you to supplemental bundle page 45, which was after the initial officer had sent her own minded to letter. There is an email from the appellant dated 24th of October 19.
Yeah.
Again, my lords, there's no reference to the job in that, to the prospects of employment. The driver we see in that email was health difficulties. We know, and it's an accepted fact, that the accommodation in Switzerland was affordable and that the appellant left without any rent arrears. And there are various places, but including supplemental bundle, page 28, which is the case notes. So there was no indication of pressed financial circumstances and no indication she had to pay for any accommodation in the UK, including Ms. Towson's accommodation, where she was staying temporarily, it is accepted, by the appellant, while this plan is now formulated, but never formulated before the county court, was in effect. So there was no reason for the respondent to think there was a plan which involved prospects of employment in the United Kingdom. And that's the reason the Section 184 decision, the initial decision, is made in the terms that it is. That is the reason why the review decision is made in the terms that it is. Although I accept that there are some references to employment in that review decision. As we see, again, it's framed in the light of the questionnaire responses which were received on the 1st of June from the appellant. Now, my lord, indeed, the timescale, my lord, has it a little bit late on terms of the opportunities for inquiries, because there is in fact an earlier letter inviting representations than the minded to one.
Yes.
And that's the one on the 6th of February, supplemental bundle, page 51.
Yeah.
My lords are probably aware that there are statutory review procedure regulations which require an initial letter from the, sorry, I said 51, that's not correct. Please bear with me. My lord, it's 54. So on the 18th of February 2020, Terry Sheaf, who wrote all the letters in this matter and was the ultimate reviewing decision maker.
Is Terry Schiff a male?
It is a man.
Man, right.
His Honour Judge Hellman says she, and
Yeah.
that was picked up by Lord Justice Edis in the
Right.
Decision granting permission to
Right.
but it is a he.
Yeah.
So this is a statutory requirement.
This is the regulation
Regulation
7.
What used
isn't
to
it?
be Regulation 7. I think it's now a different regulation.
Oh, is it?
Changed the number. But what used to be the regulation 6, or maybe it is 7. But in any event, it says, please provide your representations within 2 weeks. So there was an initial request at that stage, although Mr. Schiff quite rightly says we can extend that. And no representations were received, as we know, in response to that. The initial request for the review from the solicitors on the 6th of February also did not make any substantive representation. That is the page 51, to which I erroneously took you originally. So, and then we have a decision of refusal of accommodation pending review on the 4th of March. That's page 56 in the supplemental bundle.
Yeah.
And again, under merits on 57, the point is made, you've not provided any arguments for us to consider. And this is, of course, at a time when she's legally represented. Then we have the minded to letter, my lord, of course, which you've seen at some length, and which clearly directs the solicitors, whom the respondent had no reason to believe were not acting properly for the appellant at this stage, to that Trin Daddy, and to the specific requirement that the applicant has to show that she had an active belief in the state of affairs. That's page 60, my lord. There is also, in the penultimate paragraph, the point made by the reviewing officer today at this minded to stage, in the penultimate paragraph, you had lived in the accommodation in Switzerland since 2007. I see no reason why you had to come to the UK. Well, you might have thought that that would prompt a reaction in terms of, well, I had a job and I wanted that job to fund my accommodation permanently after this stepping stone accommodation being with Miss Toast. But nothing of the sort was received.
Can I ask you, if you look at page 16, beneath the italicized paragraph, there's a sentence, in leaving Switzerland, you moved into a friend's property, etc. Having first considered living with your sister, apparently this was not viable, as your sister did not have adequate space. Do you know where that information comes from?
Not off the top of my head, my lord, but I'll see whether or not I can pin that down.
Thank you. It might suggest the initial plan when she left Switzerland was to live with her sister.
Yes. It's certainly nothing which became not operative on anybody's mind. But again, it rather puts into relief, excuse me, my lord, just turn my back. Page 27 in the supplemental bundle.
Thank you.
My learned junior has come to my rescue, my lord.
Client unable to stay with sister. Is that the,
Yes.
the line? Yeah.
But in any event, the point being made by the respondent here is that there was no indication that there was a requirement for the employment to be crucial to the funding of future accommodation. That's what ex parte Lucy requires. We say, and my lord, I will not trespass on the court's ears by going through all those cases which my lord has taken my learned friend to, ex parte Tranquil or Aidan, Ephraim Birmingham, Ciftci, where there was a link, sorry, not Ephraim Birmingham, but there was a link between the moving to the temporary accommodation and a stepping stone onto more permanent accommodation. And certainly with Tranquil, for example, there were mortgages on the residential property from which the applicants were homeless, and they needed the funds from the in-business to discharge those mortgages as well as the debts on the business. So, really, my last, or my learning friend's last bastion of resort. Well, let's take first of all page 66 in the supplemental bundle. Again, one appreciates that this is at a time when the appellant was not legally represented, but nonetheless she'd received the Minded 2 letter and she'd been chased for those representations. Again, reference to employment or the prospects of employment are wholly absent from the email on page S66.
Yeah.
So therefore, my learning friend's last bastion of resort in this case is essentially to those answers to the questionnaire.
Yes.
My instructions are there was an attempt to take these answers on that telephone call, which my learning friend has referred to in the earlier page 68, but it was not possible to do so, and therefore this email was sent after and the response is given. Now, my Lord Justice Lewison has absolutely squarely put to my learning friend, the difficulty is that although question 3 asks about plans, question 8 asks about plans for housing and work, the answer to question 9 from the appellant is solely in relation to the situation of why it didn't work out at the temporary accommodation with the friend, Miss Tosin.
Yeah.
There was therefore no trigger, we say. Well, first of all, our submission is these were adequate questions, sufficient inquiries, in the light of the facts as I've put before the court. And moreover, there was nothing from these responses to the questionnaire which would make it necessary, susceptible only on Wednesbury grounds. There was nothing which required a necessary inquiry after this point. Yeah. In other words, my learned friend is putting forward a counsel of perfection. What plans did you have? Why didn't those plans work out? Sufficient for what is ultimately said to be an obvious matter. If it's that obvious, why isn't it put forward in these responses? Why isn't there an affidavit or witness statement as there were in all the other cases that deal with this link between employment and accommodation? I appreciate that it's on an inquiry's challenge, it's not necessary for an appellant to provide a witness statement to say, well, these are the inquiries which, had you made them, these are the answers. But we don't have it, unlike the other cases. So, my Lord, that's the simple answer to why in the review decision the reviewing officer doesn't go into the detail which my learned friend invites this court to hold that the local authority failed to find.
Yeah.
So unless I can assist my Lords any further.
No, thank you very much. Mr. Fitzpatrick.
Yes, just on, obviously it's a reply in law. I mean, what we submit is that the case that is, take my mask off, the appropriate approach is set out in paragraph 25 and 54 of O'Connor, that where there's information for the local authority, and we've had a whole series of cases about this special category, prospective employment and prospective accommodation, where that we had both in this case, and only one of them was addressed, and it was prospective employment, and we say that that required the statutory test under section 1912 to be applied, having regard to the guidance and obeyed, and that wasn't done in this case. Yeah. And the dividing line, as my learned friend says, well, your client didn't raise it in terms, and I suppose our response to that is it's totally unrealistic to think that she would be in a position to address the reviewing officer as to her employment in the terms my own friend referred to the passage in Trindade. Trindade was cited in relation to her accommodation. How, in fairness, would she be able to do that unless it was squarely put before her? And even in the case of O'Connor, where they were represented, and there was detailed representations, it was found that didn't raise the point about Mr. Walton, etc. Nonetheless, it was found that the reviewing officer was required to ask those statutory questions and apply the guidance that had already been given. So those are my submissions in response.
Thank you. Just one loose end, if I may. Perhaps I should have asked Mr. Evans. Does section 189A have anything to do with this case?
Doesn't take matters any further, my lord.
Because it does require the authority to assess the cause of the homelessness.
But the local authority have to do that under section 184 anyway. Because if someone's homeless, they need to look back to the cause of the homelessness to decide. For example, there's not issues of settled accommodation and what, yes. Yeah. When was your last settled accommodation is a question at that stage.
So it was in force at the time, but you say adds nothing.
Yeah, that's my submission.
Right. I think do you agree with that, Mr. Fitzpatrick?
We didn't have an opportunity while you went out to check the point of enforcement. I can email. I think it was enforced.
I think it was too. Yeah. Right. Don't leave court. We'll just go away for a few minutes and see where we are.
I'm just going to check that.
Well, gentlemen, thank you both very much for your very helpful arguments. We are going to dismiss the appeal for reasons to be given in writing later.
My lord, I should say yes, the Homelessness Reduction Act, Section 189A.
Sorry?
The Homelessness Reduction Act, Section 189A, came into force on the 3rd of April 2018. So it would have been relevant. Yes.
Right. All right. Is there anything else that we need to deal with now?
My lord, if my lord so minded to dismiss the appeal, the respondent would ask for its cost of the
Yeah,
appeal.
presumably there's
There would have to be section 26,
yeah,
Legal Aid Sentencing and Punishment Offenders Act 2012 protection.
right, and you presumably want an assessment of
Yes.
your
Yes.
costs.
Yes. I'm sure Moylan's happy to draw up the order.
Well, could you perhaps draw up an order? I mean, don't do it now necessarily because you'll want the judgment first, but that's what it's
But that's
that's what it'll be.
That's what
All right, thank you both very much.